Welcome once again to the Radical Imagination. I'm your host, Jim Vrettos. Former New York Governor Al Smith put it famously: democracy's ills are best cured by more democracy. The right to vote is the foundation of any democracy and a powerful antidote to any of those ills. Yet the U.S. Constitution, as originally written, did not explicitly state any right to vote. Rules and regulations concerning who gets to vote have been contested since the birth of the country. The enfranchisement and disenfranchisement of different groups, including racial minorities, women, young people, immigrants, felons, among others, has been the unfinished moral and political issue America's faced throughout its history. Numerous struggles, debates, and even violence have occurred around such issues as poll and literacy tests, felon and non-citizen voting, voting age, online voting registration, same-day voter registration, polling place identification requirements, mail-in ballots, redistricting requirements, and ballot access. Our guest today on the Radical Imagination is one of the foremost civil rights attorneys in the country. Oliver Hole is the director and founder of the Center for Competitive Democracy, a nonpartisan, non-political nonprofit that seeks to strengthen democracy by increasing electoral competition. He's an expert on ballot access law and is the author of Death by 1,000 Signatures: The Rise of Restrictive Ballot Access Laws and the Decline of Electoral Competition in the United States. He's been involved and won a number of crucial cases around the country, including recently in Pennsylvania, and won a 2024 federal court decision to gain ballot access for the Justice for All Party on North Carolina's election ballot. If our democracy is to survive, it will be because of the work and idealism of people like Oliver, who use their knowledge and radical love to make sure catastrophe doesn't have the final word. So, Oliver, thank you so very, very much for being here today. I, of course, borrowed that last phrase from our friend and colleague, Cornel West. Can't let catastrophe have the last word. And it's pretty dicey these days, isn't it? I mean, tell us a little about your own background and how you got involved in this sort of struggle. And tell us about the organization you founded. What does it stand for? What are you attempting to accomplish here?
Hi, Jim. Thanks. Thank you for having me. I founded the Center for Competitive Democracy after getting out of law school in 2005. I got interested in the issues that we work on actually during law school, and I guess prior to that as well. But when I was younger, I was largely apolitical, I think. I mean, I had political opinions, but I was completely turned off by the process. Um, and by
Now,
what I
give us
can.
the time frame here. You
Well,
still look like a young guy. Come on now. But
I was born in 1973, so
you missed a lot of stuff.
went off
Okay.
to law school a little bit late in my late 20s.
Okay.
And it was the era of Clinton's
Clinton.
running the Democratic Party, and I just thought that they were not. I didn't think that they were representing a real dissenting voice in our politics to the establishment, and I think that much of that was by design, a conscious shift of the Democratic Party under Clinton and prior there too. To triangulate, I think, is the verb they chose to describe their strategy, which basically meant becoming more business friendly and to some extent, or to a large extent, turning their backs on their traditional constituency of working families, consumers, um, and the American people generally. Um, so, I had my political opinions, but I was completely turned off by the process. When Ralph Nader ran for president in 2000, that kind of lit a fire in me because I just thought, here is someone who's coming along, speaking to the issues that I've cared about for a long time, and doing it more eloquently with more erudition, more knowledge, more experience, and more integrity than anybody I'd ever heard address these issues. And of course, we know that in 2000, Gore lost to George W. Bush, and the Democratic establishment set out to vilify Ralph Nader and claim that it was his fault somehow. Um, uh, and we could have a whole debate just about that
Yeah,
subject, but in my opinion, the Democrats have a responsibility for winning elections,
sure.
regardless of whether they have another
In
candidate
in
competing
in
against them.
in one of his runs, at what percentage did he win of the vote? Did it really uh remember? I think he had four different
In 2000, he was polling above 5%, which was his stated goal at the time to get public funding for the Green Party in the next election. But as often happens with minor party and independent candidates, on election day, the results are somewhat lower than the polling reflected. And, people think that that's maybe because voters decide to go with a candidate they think that can actually win the race,
right.
whatever it may be. But so Nader got somewhere around 2.8%, I think, in that
Yeah,
election.
he was still seen as the spoiler.
Right,
So the
right.
Dems lost everything because of him. Yeah,
And never mind that Gore lost his own home state of Tennessee. He
right.
lost Bill Clinton's home state of Arkansas. The Secretary of State of Florida um, unlawfully purged thousands and thousands of Democrat-leaning voters in Florida at the same time she was serving as campaign manager in Florida for the Bush Cheney campaign. So there's a million reasons that are far more consequential than any minor party candidate in that race. But as we know, after that election, the Democrats, and even to this day, they vilify Nader and claim that he's the reason Gore lost. And I think they effectively blackballed him for a long time in Washington, D.C., where he's been arguably the most effective, accomplished American citizen in the modern era in terms of what he
Yeah.
has accomplished in his lifetime. But in 2004, I was in law school, and to my amazement, Nader decided announced that he was going to run again, but this time as an independent. And I really marveled at the courage that that decision took, given the abuse and the professional consequences that he had suffered as a result of running for office. Let's be clear what the man did. He ran for office in an ostensibly democratic society. Uh, and then when he started campaigning, the Democrats organized a very public and very deliberate campaign to prevent him from running for office. Um, Essentially, this consisted of litigation that they filed in 19 different jurisdictions over the course of about 12 weeks, 29 different complaints. And they were operating in cooperation with lots of outside groups, Section 527 groups, that were coordinating this national litigation campaign against Nader's campaign. Um, the lawsuits, uh, some were campaign finance complaints filed with the Federal Election Commission, but for the most part, they were lawsuits filed in state courts challenging Nader's right to be on the ballot. Um, and while they were filing these lawsuits, they were also admitting publicly in the Washington Post and the New York Times, look, we're hoping to get him off the ballot, but if we can't do that, we just want to tie up his campaign in litigation, bleed his resources, make him spend money, um, make him focus on this litigation instead of running for office, which is exactly what they did.
And
They
and this is
ultimately,
the I'm sorry, this is the Democratic National Committee, among others, who were doing this?
Sure,
Yeah,
of course it was. Now,
of course.
Terry McAuliffe, the chair of the party at the time, um, sort of with a wink and a nod, denied any involvement. But we tracked the campaign finance reports, and the DNC hired at least one of the law firms that sued Nader in Pennsylvania. And there's lots of other connections and ties. And the attorneys were basically being very open about what they were doing. We're doing this to help the Democrats and to get Ralph out of the ballot, out of the race, and if not off the ballot, then to bleed his campaign dry. I
Yeah.
was reading this stuff in the New York Times and the Washington Post, and I really couldn't believe it was going on. I didn't even understand how this could be legal um, or constitutional. As, as I keep saying,
Yeah.
the man has a right to run for office under the First Amendment, as he always says. Running for office is the consummate expression of First Amendment freedoms of speech, association, the right to petition the government. And here was a coordinated um, effort by a national political party, one of the two major parties, um, encompassing something like 50 or 60 law firms, all told, all with the stated purpose of preventing him from running for office. Um, and just to me, it seems profoundly undemocratic that they would even attempt to do such a thing, much less that they would have any success doing it. And that's what prompted me to start researching state ballot access laws. Um, and I learned that every state has its own election law that determines who can be on the ballot. Um, in many states, these laws are pretty reasonable and not designed to suppress competition. But in many states, they are borderline and in practical effect impossible to comply with. I would suggest that Texas is one of those states, and we can talk about that in a little more detail. But sorry, did you want to
No, no, no,
interject?
go ahead.
Okay.
Yeah.
Um, and these laws really don't serve any legitimate state function, any state purpose when they become as restrictive as a states like Texas. Um, they are simply there to suppress voter choice by excluding competition and effectively monopolizing the political process for the two major parties. So I ended up writing the article that you mentioned about this subject, and I was fortunate enough to be working at a voting rights institute in Boston at the time as a clerk. And the founder of that organization, John Bonifaz, a great constitutional attorney, happened to know Ralph Nader and said, "You know who's going to want to read this is Ralph Nader." And I thought, oh, I'm not sure about that, but we'll see. And he passed along the article, and Ralph's campaign manager, Teresa Amato, contacted me, invited me down to Washington, where Ralph offered me a job working for him. And at the same time, he and Teresa helped me found the Center for Competitive Democracy. As the title implies, as the name implies, the idea was to apply the principles of antitrust law to the political marketplace. Now, that's always been um, more of an analogy because there is a political exception to the antitrust statutes. You can't um, criminalize or make unlawful conduct that is protected by the First Amendment. So when we get into the political realm, there is a wide exception for activity that would, in a normal marketplace, in a business marketplace, unquestionably violate the antitrust laws. But as this effort against Nader in 2004 is a prime example. I mean, that was a conspiracy on a national scale to
Yeah.
suppress voter choice, but it was protected by the First Amendment. Um, so
So they just conveniently let it pass and just yeah, they
we
knew
we
what they were
did
doing, and yeah.
one of the first things I did working for Ralph is to file a lawsuit against the DNC and the Kerry campaign and various other actors who were involved in that effort to hold them accountable under common law theories called malicious prosecution and abusive process. Malicious prosecution is when you file a lawsuit and you know you don't have a reasonable basis in fact or law for it, and you're doing it for an improper purpose. An abusive process is similar. That's a misuse of a particular legal process to accomplish a purpose that the process isn't intended to enable. Um, so we pursued those claims in originally in D.C. court, um, and we litigated for a couple of years, and eventually the case was dismissed in D.C. federal court for failure to state a claim, which was absurd. The complaint was chock full. We have a rule in federal pleading called notice pleading. Your complaint doesn't have to contain evidence. It just has to contain enough specific facts which, if proven true, would show that you're entitled to some kind of relief. Well, our complaint was chock full of evidence I had compiled and others had sent, of the improper intent of these folks who were suing Nader, and their deliberate efforts to misuse ballot access laws for the purpose of bankrupting an opponent. But without holding a hearing, without certainly allowing a trial or discovery so that we could obtain evidence from the defendants, the federal district court judge dismissed the case. His opinion was riddled with errors. He had cited to cases that had been reversed. There were factual errors. So we appealed to the DC Circuit, and in our opening brief told the DC Circuit this decision is riddled with errors and has to be reversed. Not least because we were entitled to have our hearing on the merits. We were entitled to take discovery. All of that was denied us because the judge simply dismissed the case. The DC Circuit, when we had oral argument, then issued its opinion affirming. And what they said is, normally we like to address the merits of the lower court's decision, but in this case, we're not even going to address the merits of what the lower court said. We're simply going to say that this case is barred by the statute of limitations. You filed too late.
Wow.
So
How do you
conveniently,
explain all of this? I mean, what these judges, I mean, these are federal judges. Now we're talking about the circuit judges. Um, I mean, not a conspiracy theorist here, but one sort of has to wonder here, how is there this unified front in a sense among judges, evidently, on this issue?
I've thought
Yeah.
about that a lot, and I don't have any good answer other than um, look, judges are federal judges are political appointees,
Yeah.
so almost inevitably they come from the establishment of the Republican or Democratic Party, or at least are um, known and vetted by those institutions, those entities. They come out of typically corporate law firms, so this isn't really in their background. They are not open to the idea that the political process is subject to this kind of abuse. Um, it's difficult to explain though, and I've seen it over and over again in the 20 years since we filed that case.
So you are
Um,
telling us, in fact, that justice is, in fact, not blind. Yeah,
I think that's
with
fair to
that,
say. I
picture
think,
of Lady Justice with the blindfold. So you're bursting our bubble on that. Well, okay, I'm being a little obviously sarcastic here, but yeah, so you're up against such powerful forces here, and you're learning that. Um, so what's the next step for you?
well, so it's always a difficult thing when you go into federal court and you have to prove your case on behalf of dissident candidates, dissident parties, dissident voters. Um, you are asserting First Amendment rights, 14th Amendment equal protection rights. You should have the ability to present evidence and prove your claims. But to your previous point, I've seen over and over again. Um, in the years since we filed the Nader case against the DNC, that often our cases are rejected, or we lose on what's called summary judgment, when you have at least a chance to present your case, and take discovery, but the courts rule against us. And I've seen in many cases, when courts rule against us, it's because they find some reason not to consider the evidence we presented in support of the claims. And then under the constitutional analysis, it's our burden to prove a severe burden on constitutional rights, right?
Wow.
That's the first step in the analysis. You
That
have to
sounds
show that
totally
that
unfair.
you
Yeah.
have to show that the claims that the rights you're asserting that are violated really are being burdened. Um, and we have to present evidence to prove that. But often courts find a reason not to accept that evidence, or not to consider it, and then to say, well, you failed to prove a burden. So this is a little bit abstract. Let me just give you a specific example. We just filed a lawsuit in Texas. This is the second time we filed a lawsuit to challenge Texas's ballot access laws. One of the theories that we are asserting is that these ballot access laws are the functional equivalent of a unconstitutional poll tax or mandatory filing fee that indigent candidates um, cannot afford to pay. These are unconstitutional, and the Supreme Court held them unconstitutional in landmark Supreme Court cases from the civil rights era. So, to try to get around this problem that we repeatedly face in ballot access cases, where courts, sort of just look at the statute and say, well, you have to get 1%, you have to submit petitions with 1% of the signatures. That doesn't sound so. Uh, Signatures equal to 1% of the vote in the previous election. That doesn't sound so bad. No severe burden, therefore you lose. In this case, we presented evidence demonstrating that no candidate or party in decades had been able to qualify for the statewide ballot in Texas, without spending hundreds of thousands of dollars to do it. None. There are no exceptions.
Essentially a
And
poll tax,
so we argue that it's the functional equivalent of an
functional
unconstitutional
equivalent.
poll
Yeah.
tax. And we presented evidence when we litigated that first case that the current market rate is well over $1 million to complete a petition drive to qualify for the ballot in Texas. The district court initially ruled in our favor, at least on some of the issues, which was really going to be a historic win, because ballot access cases just don't win in Texas. But the state appealed, and we got to the Fifth Circuit, and the Fifth Circuit, uh, again in a familiar refrain, ruled that we hadn't established a severe burden on constitutional rights. And the court said, well, the plaintiffs have presented some evidence about the cost of conducting a petition drive, but we don't think that evidence is a consequential burden in this case, because none of the plaintiffs were actually spending that money now while we are litigating the case. Now, this is legal
Wow.
error for a couple of reasons. First
So,
of all,
yeah.
you don't have to be spending the money right while you're litigating a case to be able to present evidence of how much money it costs when you do have to do a petition drive. So the rules of evidence say that our evidence was admissible and it was relevant, and therefore it had to be considered by the court. But the court said, no, it's not consequential. We're not going to address it in this case. And because they excluded all our evidence effectively, they were able to say, look, there's no severe burden here, and therefore you lose. So that's the kind of legal
Thinking,
maneuvering
yeah, legal
gymnastics, you might
maneuvering.
say.
Exactly. Exactly. Wow. Well, let's talk about a victory here. You did get the Justice for All Party uh, on the ballot in North Carolina in 2024. So let's lift up the audience here a little bit, or try to, that it can be done. You did it. What worked there? What was different, or how did this come about?
Um, and thank you for mentioning that. We have won several cases and made major reform in significant states. So we do win cases, and it's always more fun to win than to lose. And I'm happy to talk about one of those wins. Um, this was really an egregious case in North Carolina in 2022. Oh, sorry. There were two cases in North Carolina. Let me just start with the first one. In 2022, we won on behalf of the Green Party. And this was really egregious what happened. The Green Party um, collected enough signatures to comply with North Carolina law, submitted their petitions on time, did everything correct according to North Carolina law. But the North Carolina Board of Elections still would not uh, certify it as a qualified political party. And meanwhile, the Democratic Party of North Carolina and the DSCC, Democratic Senatorial Campaign Committee, were filing complaints alleging that the Greens had committed forgery and fraud in their nomination petitions. And then it was a partisan vote in the state board of elections. 3 Democrats voted to deny the Green Party qualification. The 2 Republicans, somewhat dumbfounded by the whole process, said, "What are we doing here? This party has complied with every provision of North Carolina law. We don't see any evidence of fraud here, and we've never done this before." But the Board of Elections still refused to certify. So we filed a federal lawsuit. And it was the complaint basically just stated, look, this party has done everything it's required to do under North Carolina law, and the state board of elections is still refusing to certify it. There's no basis in this in law for this. Now, the Board of Elections claimed to be investigating evidence of fraud, and the Democratic Party intervened in the case and plastered their papers with allegations of fraud, none of which they could substantiate. There was, as in every effort when you collect tens of thousands of signatures, as you're required to do under state law, you'll find signatures that don't match up, or usually what happens is tens of thousands of signatures are invalidated based on technicalities, like a voter's current address doesn't match their registered address, or William signs as Bill, or whatever it might be. And that's a qualified registered voter who signed a petition whose signature is invalidated based on that
It's
kind
not
of
it's not
technicality.
flagrant abuse in a sense. It's right.
Right.
Technicality. Right.
Right. But the Democrats were alleging fraud, and the Board of Elections was saying we're conducting an investigation into fraud, and that's why we can't certify this party. Well, as the litigation went on, it became clear that there was basically almost no evidence of anything that you would consider fraud, and there was never any allegation that the Green Party had committed fraud. There was just allegations that some signatures on their petitions were signed by people who claimed they didn't actually sign them, that sort of thing. But there was never any implication that the Green Party was involved in any of it, and really never any evidence that there was anything in significant numbers that would affect the outcome. So, for example, even if all the allegations were proven correct, and they were not, it wouldn't have been enough signatures to justify keeping the party off the ballot. They still would have been over the requirement under state law. So the federal court allowed this process to progress, and then eventually entered an order directing the State Board of Elections to certify the Green Party and to put its candidates on the ballot. The Democrats tried to take an emergency appeal to the Fourth Circuit, and they did what's called requesting a stay pending appeal from the district court, which is what you're required to do before you can go to the Court of Appeals and request a stay. So they rushed into court, asked the district court, please stay your order, don't put these candidates on the ballot, we need a chance to appeal.
Mm.
The district court, a judge named Judge Deaver in North Carolina, just wrote excellent orders, well-reasoned, well thought out, complete commanding grip of the factual record and the evidence. And when the time came for the Democrats to ask for a stay, he wrote a scathing order, in my opinion. He may not characterize it as scathing, but admonishing them for their efforts to interfere with the Green Party's petition drive. So they were claiming that the Green Party had delayed, and it was really the Green Party's own fault that it wasn't on the ballot. And Judge Deaver said, no, the evidence in the record shows that the Democratic Party itself is largely to blame for any delay. The Green Party did everything it was supposed to do on time, and they did it in spite of deliberate attempts by the Democratic Party to interfere. In this
Was Judge
case,
Deaver an appointed Democratic judge or Republican?
I don't know. I
Or
think
does it
he may
make
be a Republican, but
it just?
I try not to pay attention to that because I
Yeah,
don't
I
think it should
noticed. Yeah, I
matter.
know when you
Yeah,
say very political, you're on the side of the dissident, yeah, I understand. Yeah,
yeah.
it's
Well, I'm on the side of fair process, and
yeah,
so I don't think politics should enter into it. And these cases, when we bring them, I try to depoliticize them as much as possible. This is about constitutional rights and freedom of speech, petition, and assembly has
it's
nothing
a
to, and
great
voting, of
approach.
course.
That's the way
Yeah.
to go, really.
But in this case, we submitted evidence into the record of recordings of Democratic Party operatives calling people who had signed the Green Party's petitions and texting them repeatedly, asking them to remove their names from the petitions. There's not even a process under state law to remove your name from a petition, but they were still asking these folks to do it. And it was harassment, really. Um, in one case, the chair of the North Carolina Green Party received a phone call from an operative who didn't identify himself, but asked him to remove his name from the Green Party petitions. And the chair recorded the conversation and said, "Now, why would I do that?" And they said, "Well, you're going to help. You're going to help the Republican win. You've got to help. You got to remove your name so the Greens aren't on the ballot, so that the Democrats can win." And and um, and he said, "Well, who are you calling from? Who are you representing? Are you calling from the Green Party?" And the guy says, "Yes, I'm calling on behalf of the Green Party." So supposedly the Green Party was calling its own petition signers, including the chair of the party, and asking to be removed from the petition. And in other cases, they were identifying themselves as calling on behalf of the State Board of Elections. So this is the kind of interference and harassment that they get up to in conjunction with these frivolous lawsuits that they file. And so when they lost in the district court and they appealed, Judge Deaver said, "Look, you guys come to this court with unclean hands. You evidence shows that you interfered in the petitioning process and delayed the certification of this party, and now you're claiming that it's the party's fault that it's not on the ballot." Um, well, they tried to appeal to the Fourth Circuit, but I think they ran out of time. The ballots had to be printed, and so in that case, the Green Party qualified. 2 years later, in 2024, Cornel West and the Justice for All Party ran into the exact same phenomenon. They successfully petitioned to qualify for the ballot under state law. The Democrats claimed that here's their claim, that Cornel West uh, was not really entitled to start a political party because he identified as an independent. Now,
Yeah,
there's
so
about 75 years of Supreme Court precedent recognizing that Americans have a First Amendment right to form a political party for any reason or no reason whatsoever.
sure.
Uh, and the Democrats and state officials or the Republicans have nothing to say about that. So when they come into court and have a high-priced law firm dressing up these claims to try to prevent a candidate like Cornel West from being on the ballot, even though he qualified with North Carolina law, they are really asserting what, in my opinion, are frivolous claims that are foreclosed by 75 years of Supreme Court precedent. And that's basically what the court found in Cornel West's case. And so we won that one as well. But, I mean, the idea that these attorneys can come into court and with a straight face allege that someone doesn't have the right to form a political party
Yeah,
because they've said that they're an independent,
unbelievable.
it's frivolous.
Wow. Well, I we need to do this, but we need to jump to what, of course, the Trump administration is trying to do. I mean, which I don't know what they're pulling out of their hat, but it must be even more frivolous and more Looney Tunes than what you've been describing so far.
Well, I
I
would
mean,
consider it. Sorry, go on.
yeah, no, I'm just, I should use different language here, but you know what I'm saying. I mean, what are you expecting? We already can see what is happening. What are you expecting in as we approach midterms here?
It's it's frightening, and I would go beyond using the word frivolous to say lawless, because Trump has already indicated that he thinks that he may not have to nationalize the elections, whatever he means by that.
National
There's no pro
Guard, bring
Yeah,
in the
there's no
next,
provision
who
in
knows?
federal or state law to allow the federal government to nationalize our elections. He
Right.
has also said that he doesn't think we really even need to have an election in 2026. And so the National Guard is marching around Washington, D.C. You see them everywhere. Um, and um, I will not be surprised if he uses some pretext to invoke the Insurrection Act and then either to cancel the election or to somehow try to nationalize the process. And that could involve taking control of polling stations and physical control of ballots. Um, Really, I think we're watching what Trump is doing in all over society in every context, going after the media, subpoenaing journalists, coercing broadcast companies and media companies to enter into multi-million dollar settlements of cases that are frivolous. Suing 60 Minutes over an edit to an interview that they did with Kamala Harris, as if that's not standard practice in broadcast journalism. Um, and I think basically everyone knew that lawsuit was frivolous, and yet it was still settled. Because there are other stakes, other issues at stake. Mergers need to happen, and other corporate interests. And so, a frivolous lawsuit like that will get settled, and Trump will collect millions of dollars in a settlement. He's going after universities. He's going after late night comedians, right? He tries to get Jimmy Kimmel off the air. Um, so this is authoritarian stuff. It's not.
Museums, concert halls, yeah.
Yeah, I mean, this is not
So
a dress rehearsal. When people talk about the descent from democracy into autocracy, we're actually watching it happen. This is how it happens. So my fear is that it will continue to happen. It is continuing to happen, and the next step is direct interference in the electoral process.
so we are left with what? There are people like you out there. There's certain, are we without guardrails at all? Is it now dependent upon the masses of people to resist in every way possible, nonviolently? Um, what do you see happening, possibly,
First of all,
or
we're
needing?
not we're not without guardrails. The federal courts have been very good about enjoining Trump and his unconstitutional, unlawful conduct. The Supreme Court, not so good, um, and that's a real concern. But for the most part, I believe the federal courts have been doing their duty to uphold the rule of law and the Constitution, and I believe they will continue to do so. Um, People need to become engaged and active and exercise their rights to vote and to speak and not be intimidated and not be suppressed. Um, and they need to ensure that that vote is correctly and accurately counted. Remember what the Republicans did in Florida in 2000 when the recount was going on. They called it the Brooks Brothers riot, right? Because all these guys were down there banging on the windows of the election office while the recount was going on, dressed in suits and ties. Well, they know how to mobilize when the outcome of the election doesn't go their way, and the American people need to mobilize like that as well. In the bigger picture, It's somewhat of a mystery to me why Democrats aren't doing more to stop Trump now and to hold him accountable, and up to and including impeachment. Look at the list of impeachable offenses this man has committed just in the second term, not least of which is starting an undeclared war without authorization against Iran, without authorization and apparently without any reason. The American people have never been told, why are we invading Iran? Why are we dropping bombs on Iran? Um, there's never been a case made for that, and Trump doesn't even bother to try. That's how bad it is. He is assassinating hundreds of people without due process in the Caribbean, claiming that they're drug dealers without evidence ever presented and without due process. We don't just kill drug dealers, even if they are drug dealers. We
Yeah.
sentence them, we try them, we convict them, and we sentence them if they are proven guilty. We don't just assassinate them. Um, the corruption with the crypto ventures that Trump has engaged in, where foreign countries are buying into his crypto company to the tune of hundreds of millions of dollars, and there's just no accountability whatsoever. Well, there is one thing that the Constitution provides for a president who commits these kind of offenses, and that is impeachment and removal from office. Now, I understand the Democrats are reluctant, I believe, because they think this has been done twice before and it failed. So why shouldn't it happen? Why should we try again, especially before the midterms when we don't have control of Congress? In my opinion, impeachment is a requirement under these conditions. A president who behaves this way must be impeached, setting aside all political calculations. It's just a requirement under the Constitution. That's what it's there for. And when a
Well, and
president commits,
also, right, Oliver, we're talking about, I'm working with psychiatrist James Gilligan and Bandy Lee. You may have heard of Bandy, of course, had, edited the book, The Dangerous Case of Donald Trump, in which there's genuine understanding that there is some deep-seated, profound emotional issues here, and that removal by some sort of what was it, the 25th Amendment, because of
yeah,
mental incompetency, and but how does one go about that in that direction? I mean, it doesn't take that, you don't need to get your complete your psychiatric residence here. You just, I mean, come on, we could just see that the guy is totally erratic, and he's all over the place, bouncing around, and um, he's not the evil genius here. There is something deeply, deeply emotionally wrong with this person. So, is that a possibility? Is that, I know that Bandy has been talking to some of the politicians, uh, going, attempting to go that route, some of the senators perhaps. Is that a possibility?
you know, one thing I always notice about Trump is that he doesn't smile. He doesn't laugh. He doesn't smile unless he's saying something cruel. And
Yeah.
I think that's very indicative of his psychopathology.
He's a
I think,
sadist.
yeah, he is a dangerous and deeply unstable person. Um, I think that the 25th Amendment would be appropriate to remove him, but I also think it's a non-starter because it requires the entire cabinet
Yeah.
um,
Yeah.
to agree to it, and he has total control not only of his cabinet but of the Republican Party. Um, and so I don't see that as being a viable way forward, appropriate though it would be. Impeachment is, of course, also, uh, seems unlikely, but at the same time, as I said, I think it's a constitutional necessity, regardless of the politics. But beyond that, I think the Democrats are incorrect. I think that it is a politically winning strategy for them to be trying to hold this man accountable rather than throwing up their hands and saying, we can't do anything about it. We don't control Congress. So I think that the American people want to see a party that considers itself the only legitimate opposition in this country to actually act like an opposition party.
But we
What are they
see that
doing?
party. I'm sorry to interrupt you, but we see that party splintering again and again. They're
Yeah.
not. They're again at each other's throats. We're going to see it in Michigan and so on, all over the place. So again, we the issue of getting someone like Cornel West or any third progressive party on the ballot is pretty difficult, if not impossible at this point, right? Politically. So, but that doesn't mean those voices aren't being heard, and they certainly will. I know Cornell's out there as best he can. And um, I wonder just for a couple minutes, if we just go back a little bit, because I don't know if I mentioned to you, I did study with Richard Cloward as a grad student in sociology, and I was this, I guess, back in the mid 90s when Cloud and Piven wrote the book, Why People Don't Vote. And they were behind, I'm sure you know, the voter motor bill. Now, that was under Clinton now. So, do you have any comments about that? Those attempts to open up, maybe feeble as they might have been, but they were still attempts to open up the party, the establishment, to a more progressive vision by becoming more and more inclusive and giving people more of the opportunity to vote and so on in public arenas. Voter bills, for example, so they could vote at the motor vehicle stations and so on. Are we way past that now? Is it, as Cornell would say, both parties are beyond redemption? Um, is there any possibility of taking the Democratic Party in some way to take more progressive stand that would open up the the population and give people much more opportunity to be more inclusive? And of course, I think at the root of the fears of people like Trump is they can't win if that happens. They can't. So they're going to fight like hell to throw off anybody they can to divert attention. And as he's always doing. I don't know if that was a question or not. It was just when I just maybe it was just a ventilation there, but I'm interested in what you might make of it.
Well, a few points. I mean, first of all, I don't think that we should blame voters for apathy when we don't design a system that encourages them to participate in the first place.
Or for them to see the real difference between the parties. That's what
Correct.
Cloward and Piven were saying. You would get people out there if they did. So it's not Tweedledee and Tweedledum. Go ahead. Sorry.
Right, sure. Look, the United States stands alone when it comes to our electoral system. We've talked about the proliferation of democracies throughout the world. None of them emulate the United States electoral process with our electoral college that allows candidates to win even though they lose the popular vote, single member districts with first past the post elections. In other words, we divide up our electoral map into districts where one candidate runs against another candidate, and the first one to get a majority wins. I mean, there are all kinds of reforms that we could make to that system to make it more democratic, to make it more likely to encourage participation, and to make it possible for more political parties who are more representative of the electorate to participate. One would be to eliminate these single member districts and go to multi-member districts with some kind of proportional representation. One of the reforms that is gaining some traction is ranked choice voting,
Yeah.
which is being used in certain elections in the state of Maine, and then also in places like Berkeley, California, and Tacoma Park here near DC. And ranked choice voting, instead of choosing one candidate or the other, you rank them 1 through 5, whatever it may be. And if no candidate receives a majority, then the candidates who are ranked fifth get thrown out, or the candidates who come in last, votes for them are thrown out, and then the second vote that the voter cast, ranked number two, that's the one that counts until some candidate gets a majority. I didn't just explain it so articulately there,
No, no,
but
no.
it's
We
actually
got
quite
it. I think
simple.
it's been
Yeah.
tried in New York too, or they're thinking
Yeah,
done
and it's
here
quite
too.
simple. It's being used in elections here already. There's no problems with it. Voters aren't confused by it. We all know how to rank our preferences and
Right.
then to tabulate the results. So there are things that could be done to encourage more participation and to make our electoral process more representative of the electorate, but we don't do them. And until we do, I don't think we should blame voter apathy when we have historically anti-competitive, uncompetitive elections. We just filed a lawsuit in New Mexico on behalf of the Forward Party, which had petitioned successfully to qualify as a new minor party. Um, but under Mexico's unique law, despite being a qualified minor party, it now each one of its candidates has to submit their own separate petition to qualify for the ballot, and it just involves a huge number of signatures, over 100,000, just to get candidates for statewide office on the ballot. Well, without the Forward Party candidates on the ballot, several of the races for statewide office, like Attorney General and State Auditor, other statewide offices, are uncontested. A Democrat is running unopposed with only a Republican running as a write-in candidate. So
Right.
in New Mexico, a majority of their state legislative races are uncontested. One candidate runs unopposed. That's a majority of their elections for state legislature.
And
That's not an
Oliver
election
is
anymore.
exactly. And Oliver, don't we hear over and over again? There's only a incumbency is the incumbents are going to win, and there's only a few very selected contests even left to even bother to vote for and so on. What about what is it now? One third of the Senate is over 70 years old. I mean, not trying to be ageist here, but I mean, we're doddering, we're in wheelchairs. Listen, I'm above that age myself, but I mean, the point is, you got to do your be able to do your job here. So we're talking about parties that are so out of touch with the great masses of people. And I again, how do you've been so articulate in trying to come up with ways to make things more competitive. And I think again, it's opening up the system and opening up the rules and regulations um, that allow for more inclusive voting and getting people out there who are open to new visions. Um, I mean, that's what we're left with, yes. And but one last question on this one. Uh, do we put much faith in the Democratic Party to do that? I mean, you pointed out how ruthless and vicious it was toward Nader and actually toward Bernie for that matter
Yeah.
and Cornell. I mean, so what are we talking about here? What
Well, and
the
they've now
Republicans are
they've got
gone. We know that. Okay, they're off in the deep lagoon. Um, so in the remaining 2 or 3 minutes we have here, just try to summarize your efforts in the next few months.
Well, I will say on the Democratic side, the energy is coming from the DSA candidates who are um, exerting their influence and power within that party, and they are winning primary elections. And of course, the establishment has their knives out, and they are terrified that the Democratic Socialists of America are going to take over the Democratic Party. I don't think that's going to happen, but I think it's a good development that they are wielding real power within the party. And I think they're putting up credible candidates who are energizing the electorate. And we'll see. You mentioned Michigan. The primary election is today. We'll
Today.
see
Yeah.
how that resonates with the voters. Um, but I wanted to go back to this issue of politics because my organization is not political, as I've said, and we focus on process, on opening the process, and on protecting constitutional rights to participate in the process. So We represent libertarians, we've represented the Constitution Party, independent candidates, the Green Party, and now the Forward Party. The point is that all of these voices have a something to add to the debate, and the theory that the marketplace of ideas should prevail here, and that's what we're missing in our politics today, especially when we exclude everybody but the two major party candidates. I go back to 2004, 2003, in the run up to the Iraq War. Ralph Nader, the independent candidate, was strongly opposed to the invasion of Iraq. So were the Libertarians, so were the Greens. The two major parties were all in, both the Democrats and the Republicans. And
Right.
that's what we lose when we suppress competition in the electoral process, is that we don't have dissenting voices who, by the way, were totally vindicated by history.
Absolutely. I think that's a profoundly important uh, statement that you've given us here for this case as a final answer to our show here. I think that it's crucial that you maintain that sort of strategy. Otherwise, they'll try and destroy you too. And this guy is just a partisan hack and or whatever. But no, I couldn't agree with you more. You're taking the position that I think makes a lot of sense on a lot of different levels, moral, political, and so on. So, Oliver, thank you so very, very much. This has been a real pleasure and honor. I know it's taken us a while to get this going, but it's been well worth the wait. And I wish you all the best, obviously, personally and collectively for our uh, very damaged democracy. And let's, as I said in the introduction, we're not going to let catastrophe have the final word. So onward. And thank you again so very, very much.
Thanks
Appreciate
very
it.
much, Jim. I really enjoyed speaking with you. Thank you.
Thank you. Thank you, Albert. Take care. And thank you all very, very much for watching us here on The Radical Imagination. I'm Jim Vrettos, your host, and we'll see you again next week on The Radical Imagination.